The Alternative Corner, where we will follow topics of interest other than boxing. At October Red, we always want to engage with our listeners and accommodate what our viewers want to listen to. Feedback is essential. Feel free to tell us yours. Enjoy episode 3, where we discuss paragraph 37 to 86 of the completed libel case from claimant British writer, director, and actor Noel Clarke vs The Guardian.
Hey, good morning, good afternoon, good evening, good night, wherever you are. I'm Abs of October Red and welcome back to the Alternative Corner. In this segment, the first few episodes, we're concentrating on breaking down the libel case between Noel Clarke as the claimant and The Guardian as the respondent or the defendant. We've initially broke down paragraphs 1 to 36 of the judgment. We're moving on to 37 to 54 of the judgment, and this is because this is where the witnesses are introduced and you can kind of get a feel for the bones of the case, where this evidence has come from and what Noel Clarke himself had to say about it. So welcome to all of you. Once again, I appreciate your support, but without further ado, let's get into it. You might hear me sipping my coffee. It is morning time. I've just come off a lovely run in the cold and the wet. Welcome October, the best month of the year. But here we go. So from paragraph 37, the judgment shifts to Noel Clarke's own evidence. He submitted multiple witness statements, I think there was about 15, describing himself as a family man, devoted to his wife and children, and as a pioneer for Black British cinema. He denied the allegations entirely, calling them false, malicious, and career-ending. But under cross-examination, this is when we started to see a bit of flaws in what he was saying, a bit of inconsistencies, and I'll go into that. The judge noted that Clarke gave inconsistent answers, evaded questions, and sometimes offered explanations that the court deemed as implausible. Now, like I said, a lot of this is going to be subjective, so at the end of the day, they're in the court. It's down to the justice to make their decision. They are supposed to, as you know, be balanced, fair, transparent, all the good stuff that comes with having a judge. That's why you have a judge. They're supposed to be impartial. They're not supposed to be friends with either side. So when you hear the word implausible based on what? We could dig into it, but that was the answer that was given. The judge noted that his account had often been changed when faced with documents or testimony that didn't fit his version of events. By paragraph 54, the judge makes her position clear. Clarke was not a reliable or credible witness. His evidence did not withstand scrutiny. Now, obviously, I'm not saying who's lying and who's telling the truth, but when something's happened and you know what's happened and you're confident in your truth, it doesn't matter what they throw at you. When you know that you're saying the truth, your story won't necessarily change. You may apply a reason to why something happened, but your story will never change. It will remain consistent because it's the truth. That's why they always say it's harder to lie than it is to tell the truth, because you've always got to remember your lies. Because one lie leads to 2 lies, leads to 3 lies, and before you know it, you're getting yourself into a confusing situation and you don't look very credible. But also in court, under pressure, you're not lying, you're panicking. You're trying to make yourself look as innocent as possible. Therefore, you're regurgitating stuff. You're in a state of panic and it just doesn't look credible. It's easy for me to sit here on my settee and say, if you go to court, you've got to be calm. because it's a daunting environment for anybody. But stand in your truth. If you believe what you're saying is the truth, stand in it and be solid with it. If the evidence is stacked against you, unfortunately, whether you're innocent or not, there's nothing you can do about that, because it's evidence that stands up in court, not necessarily the truth. Okay? So the case details, to summarise Clarke's statements, positioned himself as a family-orientated cultural trailblazer, which we know is true. I think he's quite private about his family. Denied allegations flatly, claimed conspiracy, exaggeration or fabrication. Now he's well within his rights to do that because you've got anonymity. He doesn't know who he's standing up against. There was allegedly 4,400 pages of documents, evidence against him. There were recordings, identities are withheld. So yeah, he can say that. In his cross-examination, he became evasive, shifting explanations. And then the judge thought, no, you're not coming across quite credible here. And when the judge is saying that, at a certain point, things aren't necessarily looking good for you. So we look at the pros and cons, and we always start with the claimant, who is Noel Clarke. So he gave an emotional narrative, family man, pioneer, got his denials formally recorded. The cons: the judge found him evasive, inconsistent, and evidence undermined his credibility permanently. So then we look at the Guardian, the pros: cross-examination exposed contradictions, credibility finding in their favour bolstered the truth defence. Remember, we had the two parts of the defamation for the defence that they can rely on, the truth being one of them. Cons: risk juryless trial means the judge's assessment of credibility is final. No jury or sympathy. And I'd say that's a con for both sides. I wouldn't just say that's a con for the Guardian, because that's it. Once justice made her mind up, yeah, it's not looking good from there. So we look at the supportive witnesses for Clarke, and this is paragraph 55 to 70 of the judgment. Clarke wasn't alone in court. He brought witnesses from the film industry to speak on his character and conduct. Some described him as professional, generous, and a mentor. Others denied seeing him as inappropriate, denied seeing any inappropriate behaviour on set. But the judge drew an important distinction, or you could call it an inference. Positive character evidence doesn't disprove specific allegations. Just because one colleague never saw misconduct doesn't mean that others didn't experience it. In some cases, witnesses admitted they were not present during the key events, or that Clarke controlled the set so tightly that misconduct could have gone on unnoticed. The judge concluded that while some spoke genuinely, their testimony could not outweigh the volume and consistency of the allegations against him. Remember what I was saying about the evidence? Evidence stacked against him, 100 voices to one. As an example, it doesn't really look good. And like I said, it doesn't matter, really, whether you're innocent or not. The more witnesses you've got, and the more the witnesses are classed as credible, whether you're innocent or not, it's not going to look good for you. So they've summarised the case details: Clarke witnesses, industry colleagues, friends, collaborators, themes: supportive, professional, mentor figure. Weaknesses: limited scope, often not present at the time of the alleged misconduct. The judge: credible in their way, but not decisive. Then we move on to the pros and cons. As ever, we start with Clarke. He showed some industry still respected him and counterbalanced negative narrative. But the cons: supporters lacked direct knowledge of incidents, couldn't outweigh the 20 plus accusers' accounts. Now, Could he have turned that in his favour? Supporters lacked knowledge of incidents. Well, if they didn't see any incidents, they weren't around for any of the incidents, they're going to lack knowledge, aren't they? Because if they were there for the incidents, that means they were part to it. Yeah? Therefore, there couldn't be witnesses for credibility. So I don't know about that there. However, odds stacked against him, 20 accusers to him. So then we look at the Guardian, the pros. Judge accepted supportive evidence but said it didn't cancel the allegations. Framed as limited, not undermining the Guardian's reporting. Cons had to avoid looking like they dismissed witnesses unfairly. Did they take into account his witnesses? I know there was a witness that they did try and summon. I'm trying to find the actual paragraph of where it was, which didn't help Noel at all, because I don't even think they could find a credible excuse for him not turning up. Let me see where it is. There's an actual paragraph. That they actually went into quite a lot of detail for it. Witness. But he just didn't turn up. But we'll get back to that. It's definitely there, and it's one that I wanted to go into because it definitely didn't help. Because it just looked like he said he was going to be a witness, and then he decided that he just didn't want to turn up. So we look at paragraph 71 to 86 of the judgment, and this is about the anonymous witness and the court's balancing act. The most sensitive section covers the anonymous witnesses. These were women who testified under pseudonym, so aliases, anonymouses, such as Imogen, Maya, Sophia, and others. Protected by reporting restriction orders, the RROs we spoke about in the beginning. Their testimony described unwanted touching, sexually explicit comments, bullying, and the misuse of private messages. Now, these here, unwanted sexual touching, sexual assault, sexually explicit comments, harassment, bullying can come under harassment as well, and the misuse of private messages. Misuse of private messages is malicious communication. So all of these are arrestable offences. These are crimes. So this is where the police could have been sitting in the courts gathering this evidence. They didn't have this potential evidence before because they can't go and do a double jeopardy on him. It has to be new information. I don't know how many witnesses were reported to the police in the initial investigation, but all of these things are screaming crime. That's not civil. So the judge carefully analysed how their accounts were consistent, independent, and often supported by documents or other witnesses. She noticed that the courage it took to testify anonymously in such a high-profile case, and that anonymity did not make their evidence less credible. Clarke's team attacked anonymity, arguing it made cross-examination difficult and unfair, but the judge ruled protections were essential and proportionate, ensuring witnesses could speak without fear of reprisal. By paragraph 86, the court had heard the foundation of the Guardian's truth defence, consistent testimony from multiple women, protected but credible. Case details then, to summarise: anonymous witnesses use pseudonyms, allegations, unwanted touching, inappropriate remarks, bullying, misuse of social media or messages. Judge found consistency and credibility across accounts. Clarke's attack, anonymity unfair, hampers evidence, court, anonymity justified, testimony credible. Now, why did the judge not have the same opinion of the witnesses for Clarke? Yeah, they sound genuine enough, but that doesn't mean he didn't do it. So on the balance then, these witnesses sound genuine enough, but we must investigate this further. We must have an open view on this. Yeah? Because that is what a judge is for. It's for fairness, transparency, and all of the good stuff that come with it. And that is why we do have trials, because everybody is entitled to justice. You can't just pick out somebody and say they're guilty without proving it with evidence. But is the courts leaning towards one side? Is what I'm getting at here. That's down for you to have a look at. I'm just sitting at it from a balanced point of view. Like I said, this case is long gone, it's over, but what regurgitated it is the fact that Noel Clarke was rearrested and released and items were seized. So I'm getting abreast with this to see what happens next. So as per usual, we look at the pros and the cons. The pros for Noel Clarke are: he highlighted fairness issue, accused, named, accusers, hidden. And he tried to discredit anonymity. Anything to do with any sexual offences, you are entitled to anonymity. And that anonymity can stay with you for life. Some people choose to waiver it and say, no, I want my day in court. I want everyone to see my name, know who I am, what he did was wrong, or what she did was wrong. But you are protected by that right. And it is a way to try and discredit people, but in law, it's one of the things that we have. And clearly civil, when it comes to journalistic matters, they have restrictive, the RROs that we spoke about earlier. So the cons then for Noel Clarke: the judge sided with the witnesses. Arguments about unfairness failed legally and publicly. So for the Guardian then, we look at the pros. Protected sources gave strong testimony. And when we say strong, it was independent. And when they say it was independent, it doesn't look like they colluded to get their statements together. These are individual personal experiences. It's not a copy and paste. All these 20 witnesses, I'm not saying that they don't know each other, because like I said, it's in the film industry, so you're bound to know each other anyway. But their words didn't look like there was any collusion. There may be similarities across the statements because it's the top one person that is allegedly doing these things. But the judge saw that as really credible because they were independent. And consistency of accounts, like I said, boosts the truth defence. The cons: reliant on anonymity, risk of critics saying it reduced transparency. And you're always going to get that. And there is a reduction of transparency. There definitely is. But with those type of sensitive things, it's something that's just allowed. I can go into why we have anonymity if you want me to break that down, but we won't do that today because we're going to concentrate on this. So we'll give a summary and then I want to discuss something else to close off. So Clarke's evidence collapsed under cross-examination and it's deemed as not credible. His supportive witnesses were respected but not decisive. Anonymous witnesses were protected and persuasive. Guardian's core truth defence was reinforced. One of the things that, if you go into the judgment, Clarke had a lot of his requests refused. He made amendments. late requests, and I understand they're late, and I understand we're working to timescales, and there has to be guidelines for cut-off times, etc. But one of the things that I was thinking, why is he having a lot of refused requests? And basically it went beyond what the law allows, that were too late or didn't meet the high threshold to succeed. Adding new defendants and new claims, that was one of them that we discussed earlier, because that was in paragraph 34. He tried to add 6 new defendants and a new claim of unlawful means conspiracy. He also boosted his damages to 70 million, and this was refused because it was late in the case after pleadings were settled and trial timetable fixed. Courts are strict about moving the goalposts last minute, and it risked derailing the trial. The strikeout of the Guardian's defences, which was in paragraph 36, Clarke applied to strike out the Guardian's truth and public interest defences before the trial. You're not going to get away with that, because that is their defence. Refused because strikeouts are only granted if a defence has no real prospect of success. The judge says both defences were clearly arguable, so the case had to go to trial. Cross-examining Paul Lewis, who is Guardian's investigations editor, Clarke wanted to personally cross-examine Lewis, claiming bias or bad faith in the investigation. Don't know why that was refused, but they said it's because the court doesn't allow fishing expeditions unless you can show specific misconduct. You can't drag journalists into the witness box just to undermine their process. Now, why was this deemed as a fishing expedition? Like I said, I always leave this to you guys in the comments to have a think about. When he asked for something, it's a fishing expedition. What was his evidence? Why did he want to speak to Paul Lewis, the Guardian's investigations editor? What was his gripe with him? Was it literally a fishing expedition? What was the detail behind it? Also, longer prep time for the trial. Clarke asked for long extensions to prepare bundles and evidence, refused because the trial dates were already set. And the court had to balance fairness with efficiency. Clarke had enough time. He'd filed the case in 2022. It's down to potentially a problem with his solicitors there. Changing definitions of harassment. We talked about this. Clarke argued that harassment should mean the real strict legal definition under the Equality Act or Protection from Harassment Act. And it was refused because the courts decide meaning by what an ordinary reader would understand, not by technical legal jargon. Judges refused Clarke's request because they saw a pattern. He was trying to expand or reshape the case to his advantage after the ground rules were already fixed. Now, he's the claimant. Of course, he's going to try and reshape the case to fit his advantage because he wants to win the case. That goes without saying. But the UK civil courts prioritise clarity, efficiency and fairness. They do not let claimants move the case around late in the day. So time and time again, Clarke's team asked for more defendants, more damages, more prep time, even a change to cross-examine the Guardian's editor in the witness box, but the court kept shutting him down. You may ask why, but in civil law, once the rules are set, you can't keep changing the goalpost. Judges protect the timetable, and unless your request is like rock solid in law, it will always get refused. So yeah, interesting, very, very interesting. We're going to continue and we're going to go past, I think we covered up to paragraph 64, I believe. So we're going to 86, 64, 86, same number. So today we've covered paragraph 37 to 86. We're going to carry on and cover more. It is quite a detailed breakdown because, like I said, I think it's really good that everybody does understand what the law is. In this case, albeit this one's over, it's still quite pertinent because it looks like potentially, now Clarke may have to answer certain things when it comes to the law. This doesn't seem to be no longer civil. It does seem to be going down the law route. So we'll see what happens. Ladies and gentlemen, once again, thank you so much for your time this morning. Enjoy the rest of your week, I guess. Keep your eyes peeled for content coming out Always appreciate the comments in the posts. They do make my day. Reading through some of them, funny, hilarious, some of them serious as well. Have a look through the comments yourself. The effort that you guys put into writing what you write in the comments is phenomenal. I love to read them. It's engaging. It gives me another side to look at things as well. So I don't just spiel out what I spiel and that's it. I'm interested to understand what the audience thinks about it as well. It's something different. We're going to continue with it. There will be more episodes. I'd like to say an extreme thank you as well to my sponsors, SA UK, Maximum Security, Minimum Fuss. And as we say at October Red, put my teeth back in as I sip my coffee. Stay ready.
Thank you for listening to The Alternative Corner. Most of our listeners have not yet subscribed. We kindly ask you for your support by subscribing to our channel and to share our content. October Red is sponsored by SA UK, Maximum Security, Minimum Fuss.